То есть нормально, да, запускаю?
Так,
Мне на каком канале надо быть, я не понимаю.
вам на українському.
Тобто мені прийти на
Или
український канал.
оригінал. Просто оригінал без канала.
Давайте тоді на український перейду. Hi, Ellen.
Hi, Ellen.
Hi, hi.
I have to.
Мгм. Мгм. Так, security enable waiting room. Люди приєднувалися. Так, я всіх вітаю. Давайте перевіряти звук. Чи мене чутно,
Good
видно?
afternoon, everyone. Can everyone hear me and see me?
Хтось... Добре, супер, дякую дуже. Я вас вітаю всіх в Українському центрі медіації.
I'm greeting everyone in Ukrainian Mediation Center. Today we have an event organized under the support of Ukrainian Mediation Academy. Here is the president of this academy, Luisa Ramanatsa, and National Association of Mediators of Ukraine. We have an important event today, two events, so to say. Today we finish the month of mediation, and today we have a guest, Judge Rebecca. Let me call you just so, Judge Rebecca, because when we said that Rebecca agreed to have a speech, the people were really surprised and they couldn't believe that she agreed to that, because she is very busy, and she agreed to talk to mediators today, and today she has a special pin to support Ukraine, and she said that she's very glad to be helpful to us today. Also, I can see Helen Bass here, the director of foundation. I'm also a graduate from this foundation from the USA. More than 200 graduates of this foundation are developing mediation all over the world. This foundation helps mediators all over the world, and I think we need to start because we work today during 1 hour. I don't want to steal your time. I don't want to steal the time of our speakers. So let's talk about the rules first. First of all, I'm asking if you know how to switch the channels. Please, if you don't know how to use the interpretation function, please write it in chat. We don't have time for technical issues. Also, we have because we have this limited time, we are kindly asking you to give the floor to our judge Rebecca, and after that we will have an opportunity to ask questions by means of raising your hand or just texting it into the chat. Helen, Rebecca, I see a lot of fellows from other countries. I can see Katarzyna here, and I know that Dana also tried to join us. This is a very uniting event, and we are waiting for the friends from Georgia, from Lithuania, from Belarus. So it's an international event, and we will be very glad to discuss this controversial topic. Today, our topic is mediators offer, and Rebecca said that this topic is also not easy for her. So we'll talk about it. Please, Rebecca, maybe you can introduce yourself and how you're going to start the event.
Okay, thank you. And first of all, Slava Ukraini. Thank you for the opportunity to be here and to support you. And we are in awe of your determination to have a civil and civic and life, and we want to do everything we can to support you in that effort. So thank you very much for permitting me to join you here today. I don't know what you know about my background, so let me be very brief. I've been doing mediation in the Bay Area for about 30 years, and everything from employment cases to class action cases to antitrust to fraud to commercial contract disputes, death cases, and so on. So it's a very wide variety of cases. I've dealt with every major corporation and business in the Silicon Valley. So I hope that that experience will be helpful to you today, because I've made a lot of mistakes over the last 30 years as well. So I am happy to share with you those that might be helpful to you as you go forward with whatever learnings there may be in that. Galina asked me to talk about what we call a mediator's proposal. And let me describe first what a mediator's proposal is. I'll then talk about how it's used. And then I think it might be interesting to have a conversation about the pros and cons, the arguments for and the arguments against using a mediator's proposal. And I think that's a very important discussion, because the mediator's proposal is a very, very powerful tool and has to be used very, very carefully, if at all. And I think there's a certain amount of judgment and discernment that goes into deciding when a mediator's proposal will be helpful. So let me describe what a mediator's proposal is. The mediator's proposal is that there comes a point in the process of mediation where there appears to be some impasse, and it appears to be a genuine impasse that the parties themselves, despite the fact that we may have worked for hours, for days, sometimes months to get an agreement, and we can't get an agreement. So there is a tool that can be used, this mediator's proposal, whereby the mediator says, the defendant shall pay to the plaintiff X dollars. The parties will have some time to consider that proposal. The proposal should also include any non-economic considerations in the agreement. And we'll get to a moment about how important getting those non-economic issues resolved before putting out a number. As you all know, there's the integrative process where we talk about interest in mediation, and then there's almost always a distributive piece where we're trying to distribute something that can be quantifiable, whether it's land or stock or money or what have you. And it's the distributive piece that the mediator's proposal can be most helpful with. That is the numbers piece. So the mediator proposes that the one party pays the other or distributes something to the other that's quantifiable. There is a time for consideration of the proposal. Everyone has to respond who's part of the mediation process by a certain time, and it's very important to have the time of day, the date, and to whom they respond and how they respond. In my proposals, I have them respond to me and my case manager. You will say yes or you will say no to this proposal, and you'll do it by this certain deadline. The mediator holds the responses confidentially, so that, for instance, if one party says no and the other party says yes to the proposal, the party who said no will not know that the other party said yes. So the mediator's proposal works when I get 2 yeses. I think twice in 30 years I've gotten 2 no's, and then we later worked out the problem. It is less common to have one party say yes and one party say no. But that response has to be held confidentially and cannot be revealed in any way by the case manager or myself. Now, one says, well, what's the value of that? The value of it is that when we're in these distributive portions of the mediation where we've gone back and forth, for instance, my case yesterday lasted 14 hours, where we go back and forth over the numbers. We also talk about interests, of course. We talk about other concerns, non-economic concerns, and so forth. But in the distributive piece, the grand bazaar piece, right, the bargaining piece over the things, the quantifiable things, and you go back and forth, there comes a point at which it's obvious that the parties are not going to get there on their own. And so the mediator can have the parties, through a mediator's proposal, think about, what if I could get rid of this conflict? What if I could resolve this conflict with this number? And they can think about it without undermining their negotiating position if the mediator's proposal fails. So, for instance, yesterday, the parties were at an impasse, and it was about, I think we started at 1.6 million was the demand, and the offer on the other side was 5,000. So you can see there was quite a difference in the number. We got to a point where one party, the demanding party, was at 750,000, and the responding party was at 55,000. Okay, so again, 750 to 55. Very, very big gap. But in between, we've been talking about brackets. We've been talking, which I'm sure you all discussed brackets as well. We've been talking about other possibilities, all of which have failed. And so I asked the parties, do you want a mediator's proposal? I gave the proposal was accepted, and we were able to craft the settlement agreement last night. So it gives the parties a chance to take a deep breath, really think very hard about what is in their best interest, what is the best exercise of their business judgment sometimes, what considerations, their considerations can be addressed, as I said, without undermining their distributive bargaining position. And that's why it's most important. And it probably the best use of it. It's also useful, particularly when there are other constituents involved in the decision-making. And for instance, there may be a corporate board, a city council, an organizational governing body of some sort that has said to the attorneys in the litigation, have said to their attorneys, here's what you can settle this case for. No more, no less, or no more than this amount. So they go into the mediation, they go into the negotiations, and they know what their reserve point is. Maybe it's an insurance company, and they've said, we have investigated this claim. This is what we think it's worth. Then they send their attorney into the mediation to negotiate the best deal they can, but the attorney is instructed you can't go over $1 million, let's say. With the mediator's proposal, one can put out a proposal that the mediator could put out a proposal that's more than $1 million. It gives the attorneys a chance to go back to their constituency, their board, their city council, whoever, their insurance committee, whoever needs to authorize the ultimate settlement. They go back to that group and they say, look, the mediator has proposed that we resolve this for more than we wanted to pay, but it still makes sense, and here's why. And it gives everyone a chance to rethink their position. That's probably the most useful part of a mediator's proposal. In other words, it sort of gives attorneys in those kinds of positions a bit of cover, if you will, in the sense that they can say, well, the mediator was in the discussions all day, considered all of the arguments, considered all of the facts, helped the parties, and here is what they believe could settle this case at this time, at this moment, knowing what we know at this time. Now, remember, of course, that the yes or no to the mediator's proposal is, of course, voluntary. You can say no. So then the question is, well, what's the downside? Why would I not want a mediator's proposal? Well, you may not want a mediator's proposal, or the parties may not want a mediator's proposal, because they're concerned that the mediator is going to do something they don't like, a number they don't want. It's either going to be too high for one side, too low for the other. And it sets expectations in parties' minds, because obviously the neutral, the mediator, holds a very powerful position in the mediation. So I never, and I think this is extremely important for mediators, I never, ever, ever do a mediator's proposal unless all parties and counsel want me to do it. And if I propose, or if I suggest that perhaps it's time for a mediator's proposal, it's because it is absolutely the last option. Either people are heading to the elevator when we were in person, or they're ready to leave the meeting, or they're just finished, they're done. My preferable position, because mediators' proposals are used quite frequently in American mediations, is to have the parties ask me to do a mediator's proposal, because that is the voluntary part of the process. And I might have one side say, we feel like this process is complete and done, and we can't get to the numbers, and we would like a mediator's proposal. Again, all parties have to agree to it. Without that agreement, I think that obviously takes away too much power from the parties, and I think it undermines the very notion of mediation altogether. So it is a tool. Parties know that it's a tool, and it's entirely up to them as to whether or not the tool should be used. I think a couple of other points about the use of a mediator's proposal is, again, the timing of the proposal, because whether it's the same day as the mediation, and by the way, we have day-long mediations here. We don't have truncated, or we don't have mediations where we pass it from one day to the other, usually, except in the most complex of cases. So the timing is extremely important. It may be the same day, it may be a week later. I may call the parties if we haven't been able to resolve the mediation in the single day. I'll call the parties later. I'll ask them if anything has changed. Should we restart conversations? Should we get the negotiations going again? Or if I feel that it's right timing and that the back and forth negotiation, the back and forth positional bargaining is not helpful. In fact, sometimes, as you know, it can be counterproductive. I will say to them, do you want a mediator's proposal? They'll say yes, or they'll say no as to whether or not they want a proposal. Now, when I ask a party, or when the parties come to me and ask for a proposal, they don't know what the proposal is going to be. They do not know what the number is going to be. And I think that's very, very important because, again, it undermines the integrity of the process. Everyone gets the number at the same time. Nobody gets a preview of the number. Now, that being said, there are times when I might say to someone, it's not going to be the midpoint. It is not the midpoint between where your position is now and where the other side's position is. And I might say, generally, it's going to be more than that, or it's going to be less than that. Tell me whether or not you want me to do a mediator's proposal. Again, because of the power that the mediator has in setting the expectations. On the non-economic portion of the mediator's proposal, because some of these matters can be extremely complex. There might be complexities with regards to the scope of the release in a commercial case. There might be issues with regards to who constitutes the class in a class action. So there are a lot of complexities, the scope of the confidentiality, to whom can I share the resolution in this mediation? Who can I not share it with? Can I talk about it on social media? Can I not talk about it on social media? These are all issues that the parties sometimes are very concerned about. And they're very key to the agreement itself, but it has no monetary value. So I think it's imperative to work out the non-economic pieces of any agreement before putting out a mediator's proposal. Now, sometimes they're interrelated, as you know, and that creates its own complications, but it can still be done. So what you would do is work out those non-economic conditions, terms and conditions of the agreement. And you say to the parties, if we were able to resolve this case on the numbers, what would you want in the agreement that is non-economic? And then we work on that for a while. And then that non-economic portion of the agreement, the terms and conditions, once we have agreement on them, become part of the mediator's proposal. So once we have those elements resolved and agreed to, then it's a matter of filling in the blank on the number. Now, sometimes, obviously, a term and condition may be that there will be X% of the number that will be paid upfront within 30 or 60 days, and then another payment in another 6 months or another year and a half. But those, again, are the kind of terms that we have to get resolved before putting out the number. Otherwise, and this is a mistake made very early in my career, what happens that if you don't have that non-economic resolved, but you get a number agreed to, now a number has been revealed to the other side, and then they want to start negotiating. They said, wait a minute, this confidentiality provision, it's really worth a lot. I want another $1 million for that confidentiality provision. And by the way, sometimes those confidentiality provisions are worth that because of reputational interests, both of the companies that may be involved or also some of the some of the celebrities that we do deal with, a lot of celebrities, of course, down in Hollywood and so forth. So it can be a very significant value, and that has to be resolved as to scope of confidentiality, or again, other terms, before putting out the number, so that you don't have somebody reneging on the number and now wanting to renegotiate. So you want to get it as clear as possible as to what this agreement's going to look like. I think the other thing is, and again, we can talk about the pros and cons of using this tool at all. The other thing is that here in the US, at least on I would certainly say on the West Coast, East Coast, most business center places, Chicago, Atlanta, New York, San Francisco, Los Angeles, and so forth, the mediator's proposal is used quite frequently in business cases, and the attorneys are used to it. So there will be times when there may be an impasse, what appears to be an impasse, and an attorney will say, well, I think it's time, Judge Westerfield, that you give a mediator's proposal, and here's what the proposal should be. They want to fill in the blank. They want to tell me what the mediator's number should be. Obviously, that completely undermines the mediation process. And I have to explain to them, no, I will not be using that number because it is a mediator's proposal, not the attorney's proposal. And I will say to them, however, if you want to put that out as an offer to the other side, I'm happy to help you do that, but it's not a mediator's proposal. So again, attorneys, and we deal almost exclusively with attorneys, are very very clever and very smart, and know how to leverage whatever tools might be available. What we can't do is let them hijack our tools. And the other thing is, I also make it clear, I'm not negotiating the mediator's proposal. I'm simply putting out the number, which I think will be the number that both parties would accept at this time to resolve the litigation. Now, this raises another issue, and that is, well, what is the mediator's proposal, the number? Is it just whatever number it will take to resolve the case at this time? Or is it an evaluation of what the case would bring, or what would happen to the case if we were not able to resolve the case and it went to the alternative to the negotiated agreement, whether that's court or arbitration or whatever the alternative to the negotiated agreement is? I'm very clear with parties. It is about my sense of, given all of the issues that we've talked about here in this mediation, all of the non-economic terms and conditions that have been negotiated and resolved, that the number is simply the number that will settle the case at this time. It is not an evaluation. Now, obviously, you all are very sophisticated in using ADR. Obviously, there are other ADR processes where evaluation of a claim may be different. And that's like early neutral evaluation and other processes which we use here in the US, and I'm sure you all use as well. So you can see that it's a very, as I said, powerful tool. It can be a very useful tool, but I don't think it's a tool that should be used without a lot of thought. It's shouldn't be used just because the mediator's tired. It shouldn't be used just because the parties are frustrated. In those situations, that's a timing issue. So maybe the mediation needs to have another day. Maybe everybody needs a break. Maybe there needs to be some sort of disruption in the process to get everybody back on track in terms of restarting, resetting the negotiation, the voluntary process of the back and forth and give and take and exploration of each other's positions. So that's in essence what it is. And as I said, there are a lot of pros and cons. I've tried to give you a little bit of an insight into what some of the pros are, its usefulness, its ability to assist with other constituency groups or governance groups that are not part of the actual mediation process. It can also help sometimes with people who are in terrible pain, people who are in a conflict. They want to be out of it, but they don't know how. So, for instance, I had a case, and this was a very sad case, young woman who was killed by a bus here in San Francisco, and she was in her early 20s. Gorgeous, beautiful, lovely, great promise. Her parents were absolutely devastated at the loss of this child. Devastated. And they had, ultimately, I think we had 3 sessions on this case. And what the mother wanted was an opportunity to show how beautiful and wonderful this young woman was. And so she brought, of course, her photograph albums and art pieces, and very, I thought, eloquently and also very emotionally shared all of this in a joint session. And that was a very important part of the process for her to feel that her daughter and her daughter's life was respected, was seen and respected. Once that part of the mediation was complete, and it was very emotional for everyone, and because of the grief was just palpable, we then had to go into our separate rooms, which is the way we do it here, to talk about money. Now, how does one monetize the loss of a child? And in this situation, the parents very wisely had good counsel, very good lawyer, and I took the lawyers out. They agreed, and we would negotiate with the other side. I would facilitate that and get to a number that the parents could then feel this was complete. This process, at least this part of the process of litigation, was complete. And it ultimately ended up that there needed to be a mediator's proposal in that case, which was accepted by both sides. Afterwards, the parents told me how relieved they were that this part of their grief process was complete, that they could move on and deal with their grief in a more appropriate place rather than in a court of law. So to bring people to that decision-making point can also be a relief to them. That's a good use of it, as far of a mediator's proposal, as far as I'm concerned, anyway, and I think the parties as well. So I don't know, Galina, if there are questions at this point about some of the how it works or when the mediator's proposal is used. And then again, I would like to open it up to some of the pros and cons of using this process. Are there any questions?
Є запитання, уточніть, будь ласка, медіатор має право запропонувати сторонам цифру.
There is a question if the mediator has a right to ask to offer the number only under the condition if the parties agree to do that. It will be the mediator who states the number. Is it correct?
Yes, right. If the parties, first of all, the parties have to agree that they want a proposal. They don't know how much it's going to be. They don't know what the proposal is going to look like. They may have some feel, but they have to agree, yes, they want the mediator to do this. And if they say no, they don't want a mediator's proposal, that is fine, because this is a voluntary process. And so if they do not want to agree to that process, if they do not want to agree to the use of this tool, I strongly believe that the mediator needs to respect that and not use the tool. Any other
Є
questions?
питання від болгарських медіаторів.
There is a question from Bulgarian mediators.
Якщо сторони не знають, що таке
If the parties do not know what is the mediation,
тобто, якщо сторони не знають, чи
I'm sorry, I didn't
ні-ні-ні.
understand the
Якщо
question.
вони не знають, що таке
what if they don't know what is the mediation? What is the proposition of mediator? Would the mediator explain what it is, and would they explain what it is?
Absolutely. I would think that that would be done very early in the process. That is part of any mediation process. Also has the contracting part of the process, right? The setting up of the mediation. And I think it's extremely important for the mediator not to assume that the attorneys have educated their parties about what mediation is. I talk to the parties about what mediation is, how we use the process, what my role is as a neutral. I'm not an advocate. And I think it's very, very important that the parties understand what mediation is completely, including any terms of evidentiary privilege or confidentiality, or whether or not you will use, separate caucuses, whether or not you'll have separate meetings, what are the rules around that? That's all part of the contracting process. Now, interestingly, I was at a program in India, and very, very astute mediators in Delhi. And the question was asked, we were in our role play, and the question was asked, will you ever use a mediator's proposal? Now, that's a very sophisticated question, right? Will you ever use a mediator's proposal? And then I had to answer, only if both parties agree, and maybe. Why the maybe? Maybe I won't use the mediator's proposal. If I get a sense that the attorneys or the parties are gaming the mediation, in other words, they're engaged in this process expecting at some point some mediator's proposal, then they will continue to posture and position during the whole mediation process, and then you've lost the authenticity of mediation. That's one of the cons. That is one of the arguments against using mediator's proposal. But I make it clear again that it is the mediator's proposal, not the parties, and when I feel that I can do it, by the way, with integrity. I do not do it in every case. I don't even do it sometimes when both attorneys ask me to, because I think there's more that can be explored with the parties. So you have to be very, very, very careful with this tool.
Дякую дуже.
Thank you. How is the number made up? How do you understand which number you should choose? Because it is a very high responsibility. It is a question from the chat.
I think
Based on which principle is the number is made?
Yeah, that's a very, very difficult question to answer. Again, because the greatest concern, my greatest concern in using a mediator's proposal is manipulation by attorneys. And as I said, we almost always deal with attorneys. My concern is that the impasse is not genuine, that there is yet more discussion that could be had and so forth. But when we get to that number, it is basically listening very, very carefully throughout the mediation process as to what are the interests of the parties, and sometimes whether or not there are monetary components in this agreement that are more important than other monetary components. So there's a real analysis and examination that goes into the valuing of the components, and it's just listening very, very, very carefully throughout the day, because sometimes folks will give you pieces of information, and of course you want to check out that information. Be careful about making wrong assumptions. But I think, again, after a certain amount of experience in these cases, you get a bit of a feel for where the case may go or where the parties may want it to go and are willing to accept. To the extent that we are informed in terms of coming to the number by the positions, the negotiating positions of the attorneys or the parties, that has some value, but it shouldn't be determinative, again, because of the gameplay that goes on in positional bargaining. And I think you have to be very careful about it. You have to get a real sense of what's driving this controversy. Is it really the numbers? Is there some non-economic issue that might assist in bringing it to resolution? So it's, I can't give you a formula. I'm sorry. That it doesn't work as a formula. But I think you get involved in the negotiation, and I think you can get a pretty good feel, even if it's Zoom mediation, by the way. It was better when we had it in person, I agree. And we're doing more in-person mediations, but people still like Zoom. There will also be times, frankly, when I will, because we deal with attorneys, I will sometimes take the attorney aside, and we will have a side conversation and get a better sense of what's driving their client. Sometimes the client, frankly, is not listening to the advice of their attorney. Sometimes the numbers may be attorney-driven and not party-driven. So these are all things that would have to be explored.
Judge
So
Rebecca,
probably a terribly unsatisfying answer, but I don't have a better one. It is
Ви
sort of a
коли-небудь,
field.
як то, жалкували про те, що ви таке зробили пропозицію?
Have you ever regretted making a proposition of a mediator? Has there ever been a regret that you shouldn't have done it?
No, no, no. If the parties say, both parties say yes, and it resolves, it's voluntary. They could have said no. So they've taken the responsibility of saying yes to it. If one party says no, and the other party says yes, I respect that. That's their decision. Now, sometimes what I will do, again, depending on the case, if I get a response, one party has said no, the other side has said yes. The party who has said no knows there's no agreement. Okay? They just don't know whether or not the other side said yes to it. The party who said yes knows there's no agreement, so they know the other side said no. Okay? So what I will do is I will go to the party who said yes and say, look, we know there's no agreement, so we know the other side said no. That's a given. Do you want me to see if I can get these negotiations started up again? And I ask the permission of the party who says yes, because even by the mere fact that I go to the party that says no and try to restart conversations, it may tip that party that said no to the fact that the other party said yes, and therefore undermine the other party's negotiating position. So I always get the party who says yes, I get their agreement that I can make an overture to the other side. And then sometimes that's what happens, and we work it out, and we get an agreement that is not the mediator's proposal, but it's another agreement. You know, now to be fair, do I regret giving out a proposal? No. Do I regret the number? Sometimes. There are times when I think, if the and I get a no, which isn't very often. This works in our system at least probably 95% of the time, 98% of the time. Very, very rarely do I get no's. But as I said, it's not the end of it, of the discussion, because I'll continue to try to probe on how to keep the conversation going. And there may be times when I thought, well, maybe the number was off. Maybe I should have, done something one way or the other. I usually do not do the midpoint and where people were left positionally, because I just think it's too obvious and too subject to game playing. And I like to do a little bit more analysis than that. And then sometimes I've had situations where I put out a mediator's proposal, and perhaps it's a city government issue, and the Board of Supervisors or the committee that deals with litigation for the board will want to know why that number. Why did you put out that number? And then at that point, you do an analysis as to why this would be a wise resolution for that group. The cost of litigation, risk analysis, just the usual kinds of analysis one goes through as you close out the conflict or settle the case.
Ребека, я правильно розумію, що якщо вони погодилися, то це потім може бути
Do you understand it correctly that if they had agreed, it could be enforced? So if they changed their mind?
That's a very, very important question. First of all, there have been situations where mediators' proposals have been agreed to. It has not happened to me, by the way, but it did happen to a colleague. It was a highly controversial case, big case here in the Northern District of California in San Francisco, and was a Silicon Valley case and hundreds of millions of dollars. The mediator's proposal was accepted. And then once the mediator announced that the proposal had been accepted, there was a change of leadership in the corporate structure. And the new leader said, no, we're not going to do the deal. At the time that the mediator's proposal was accepted, there was no written contract that had that term in it. In other words, it had not had an opportunity to be reduced to writing yet. So there was no enforceable contract. What I do with my mediator proposals, and Galina, I think I sent you a copy of what my proposals look like, is we have a mechanism, and I don't know, some of your European countries, I believe, do have this mechanism as well, where if parties have an agreement in a mediation and they sign off on that agreement at the end of the mediation, it can be enforced by the court. It's not a new contract, it's enforced as a judgment, okay? And we have a special rule around this. So when I give my mediators proposals, in some cases, I will send the parties the exact same written document, and they either accept or decline, and they do it by signatures. And then I show that it's countersigned, it's an integrated document. And if I get 2 yeses and they've signed off, then I actually have a contract, okay? Because they've accepted my proposal, they've signed, the other side has exactly the same proposal, they've signed, it's an integrated document, and it becomes an enforceable contract. And then under our court rules, again, it's kind of complicated, but if it's a 664.6, which is a special statute, then it becomes enforceable as a judgment. The other thing is, for instance, yesterday, as I indicated, we had 14 hours of back and forth. They ultimately accepted the mediator's proposal, and we used the time last night to get a signed agreement. And I quite frequently in mediations will have the attorneys, usually it's the defense attorney if it's insurance case and so forth, bring a document, bring their form document, so that we can actually have a document that is negotiated and signed the same day or the same evening, so there can't be a reneging on the agreement. But I have to say, it's very rare to have people renege on a proposal. If they do, it's because there is something about the non-economic terms and conditions that were not ironed out before they accepted the proposal, which is why that is a very important part of this process.
Я дивлюся, мало часу, але я думаю, важливе питання.
I see what is approximately the percent of your mediations? This is a question from the chat. So what is the percent of your cases ends up with the proposition of mediator? How frequently do you use it?
Well, that's a good question. I would say about 30 to 40% of the time, because frankly, I for obvious reasons, prefer that we put in the extra effort and time to explore and have an agreement that the parties embrace completely, totally as their own. and help them through that. So I would say it's a 30 to 40%. Now, that being said, I will tell you there are mediators who are known for putting out a mediator's proposal within 2 hours of the mediation. And they will just put out a number, and that's how they settle that's how they approach every single case. I don't know what their rate of settlement is. I think that's a very, very small group of mediators who do that. You have to have enormous amount of trust by both the defense, obviously, and the plaintiff's bar, and tends to be in highly, highly specialized areas. So. And again, there are some people some mediators, and I respect it, I do respect this position, who don't believe mediators' proposals are ever appropriate and should not be used because it takes too much away from the parties and is too vulnerable to manipulation.
Дякую. Дякую. Окей. 2 хвилини для того, щоб просто подякувати.
We have 2 minutes to thank Rebecca. We see a lot of participants from Ukraine, from Poland. I see people from Kyrgyzstan, Bulgaria,
Right.
and
I just
other
wanted to,
countries.
Here we are. Really, it's wonderful. Wonderful
Де
to
ви
have
взяли
this.
це?
Where did you get it?
One of my colleagues had these made up, and he wears his, and we distribute them. So yes.
Ми вам дуже вдячні.
We are very grateful to you for everything.
Well, thank you again for the opportunity. And I hope it
We
had
think we
some
can be
value.
grateful for you for everything. Thank you to the Ukrainian Academy of Mediation for supporting us in this event together with Ukrainian Mediation Center as well as Ellen Bass. Thank you for coming as well. Thank you, Rebecca. Thank you, everyone. And let's share our gratitude with hearts.
Thank you. Be well. Thank you very much. It's been an honor and a real pleasure. Thank you. Good to see my friends here. Bye.
Ми дуже вам вдячні.
Bye.
Будьте щасливі.
Thank you very much and be happy.
Right. Be well. Do good. Bye.
Bye. Дякую, до побачення.
Thank you. Bye.